Honourable members, please be seated.
Under Government Bills and Orders for second reading, Bill 19, Condominium Property Amendment Act 2022, adjourned debate. Member Irwin.
I believe I see the Honourable Member for Edmonton Highlands Norwood with about 4 minutes remaining post-adjournment last time.
Thank you. And, you know, I have to, Mr. Speaker, I have to just share a little bit about the, this very auspicious occasion. And I'm certain many people are watching, especially given the hockey game tonight. I'm positive we have at least 2 or 3 people watching tonight. But Mr. Speaker informed me that this will be the first time the person who adjourned debate was actually in the chamber and able to start. Well, not that that was a point of order, but you know what I mean. Yeah. So this is a big deal. So I wasn't planning to speak first, but I really wanted to maximize those 4 minutes, and I wanted the speaker to be able to share this tonight, perhaps with his family and others. But anyways, I'm sure I only have 3 minutes left now, and I didn't draw a point of order on that. Just before I actually did speak a fair bit on this bill, I know in previous days, and I may have a chance to speak again, but I know my comments, in my comments on Bill 19, which is the Condominium Property Act, I really wanted to just highlight the fact that you know, we've seen multiple times already in this session with this government that they've had an opportunity to introduce, you know, transformative legislation on areas of concern to Albertans. I think about continuing care, Bill 11. You know, Continuing Care Act is the name of the bill. You'd think, wow, what an opportunity to really listen to the dire concerns of stakeholders and patients when it comes to continuing care. And of course, this government chose not to. And I could name the same with multiple other pieces of legislation this session, including Bill 19. And I talked about the fact that we are not certain who in fact was consulted on this proposed piece of legislation. I talked about the fact that you know, we, in some of the consultation that we did on this bill, we heard a lot of concerns, and we had stakeholders raise a lot of questions, particularly around the tribunal process and why there's no tribunal included in this bill. You know, condo insurance, wow. We could talk about, and we have talked a lot about, the rising costs on Albertans in so many areas. You know, auto insurance, tuition, park fees, school fees, the list go on. And you know, I know in the last time we debated this bill, a few of my colleagues shared some of the concerns that they've heard from condo owners in their ridings about rising condo insurance fees. So again, the point being here, this government had an opportunity to address some of the real concerns that we're hearing from our constituents around condominiums, and they chose not to. And what I ended on in my last speech on this bill was the fact that housing remains a huge concern. And that is an issue. I admitted that I haven't heard a lot about condos from my constituents, but I have heard a lot about housing. And it's one of the top issues I hear in my riding. And every day, I witness unhoused folks, and I interact with unhoused folks, and we know that the number of unhoused folks on the streets of Edmonton and across the province, as my colleague from Edmonton Strathcona raised in question period. In fact, she asked the Premier about the lack of housing and housing supports in Calgary, and the answer was quite shameful. The answer talked about shelters, and it didn't talk, and the Premier did not talk about the need for investing in housing, particularly permanent supportive housing. And so, with that, I will I will end my remarks, and hope that we will get some answers from this government on this bill. Thank you very much.
Thank you, Honourable Member. I see the Honourable Member for Edmonton City Centre has risen to join debate.
Thank you, Mr. Speaker. I appreciate the opportunity to stand and speak to Bill 19, the Condominium Property Amendment Act. Edmonton City Centre is, of course, home to a lot of condominiums. It is a big portion of the constituency I represented. It certainly affords some unique challenges. It's much more challenging to do door knocking in a good part of the constituency outside of election periods, and there are a number of other things that come with it. But certainly with that also comes a high interest in government legislation around condominiums. And indeed, since we were in government in 2015 and inherited the condominium work that had been done by the previous PC government but not proclaimed, and so there was a lot of extensive work that had to be done to bring that forward, and some of that indeed went on long enough that it was inherited by this government and brought forward. But it's certainly something in that process that I've heard from a lot of constituents about. And indeed, I have been a condominium owner. I have been on the condominium board. I have been the president of such boards. And certainly I have seen that they are a dynamic form of democracy, Mr. Speaker. Indeed, you know, folks may comment at times about the temperature in the legislature and the kinds of disorder that they might see during question period. At times, Mr. Speaker, I would say that pales in comparison to some condominium board meetings. Now, I think we all here do believe in grassroots democracy, but certainly it's a challenging one when it comes to condominium boards, because so much of it is left to the boards themselves and the individuals involved to police. There is no speaker, Mr. Speaker, at your average condominium board meeting. You have the chair, of course, but there is perhaps limited knowledge of Robert's rules. There are a number of factors involved. Certainly condominium legislation can be complex. It can be difficult. Indeed, I've been in experiences, and not that long ago, where new ownership coming in, buying a certain number of the units, creating complications where, the board felt that we actually had to have a lawyer at several meetings to try to determine which way things were going to go. So these things can be very complex. But certainly the objective of government, in terms of governing this and trying to set out these processes, should be to try to make it as easy and as smooth as possible for these meetings to take place. And secondly, to make it as easy and smooth as possible to try to resolve these disputes. Because again, the complexities that can be involved in some of these questions, and indeed the level of emotion and personality conflict that can be involved, it makes these situations difficult. And if the only available resolution is to go to court, Mr. Speaker, that creates an even bigger challenge. It certainly does little to try to calm the situations. It certainly does little to make them smoother or easier. Indeed, it increases expense for everyone involved and can make it far more challenging. And indeed, it can deeply disadvantage individuals who do not have the kinds of financial resources to be able to hire a lawyer and take these things to court. And we have to recognize that in certain situations, a condo board themselves can have a lot of power. They have control over the purse strings. They have control over those resources. And indeed, if a condo board chooses to act in a way that perhaps is not quite ethical, it can be very challenging for an individual owner to push back against. And indeed, again, I can speak from experience in situations where I've seen presidents or other members of condo boards who worked with property managers who themselves were willing to look somewhat askance at what the actual rules and legislation might say to attempt to intimidate owners with fines that were not actually legal or take other steps that they did not actually have the authority to take. Now, what we have in this bill is a few different changes. So certainly I have no objection to the change that the minister is proposing here in terms of allowing certain votes to be done by simply by one owner, one vote, as opposed to unit factors. And indeed, I have spent my own time, Mr. Speaker, at times when we felt that we needed to take action to make changes on the condo board. And so certainly going around and figuring out how many owners we need and how many unit factors that person have in order for us to be able to win this vote, et cetera. And certainly that was some of the early things that first got me interested in a career in politics. But I recognize that when it comes to things like simply approving the agenda for the meeting, why not just have that be able to be just by a simple show of hands from the owners present? That seems reasonable. Now, I'll look forward, of course, to the regulations where we'll get further definition on some of these things. But on this piece, I do not have a difficult time trusting the minister that there's going to be some of these sort of small adjustments to try to make for an easier flow. However, I do have some concerns with the proposal that the minister is putting forward regarding chargebacks. Now, indeed, I have had folks on condo boards, at condos, at condo buildings here in my constituency, reach out to me on the issue of chargebacks. And they have indeed said, that they felt that the process that was in place made it too difficult for them to be able to recoup costs in situations where there is damage done to common property. And that's reasonable. We want to be able to find a way, I guess, for those things to be achieved. And certainly I recognize that costs, can, when there is damage to common property, then that falls on everybody. And then that's all owners that have to pay that. Indeed, as the minister himself said, these costs add up. The only way to pay for these costs is to increase condo fees. That means every condo owner, even if you're a good actor who's never caused any damage, had to bear the cost of those. And certainly, that's a reason to have concern, Mr. Speaker. I would also note that I've heard from many people who are very concerned about the fact that this government removed the cap on insurance, which in turn has also had precisely that effect, driven up the costs for the building and therefore every single owner's condo fees. But that is not the subject of this bill. But it does concern me, Mr. Speaker, that again, as I have seen, and certainly as I've heard from every constituent, it is possible for a board to be, shall we say, disingenuous, to choose to target a particular owner. And what this change would do would make it more difficult for an individual owner to be able to appeal that. Because again, the only option that they would currently have is to go back to the courts. And that, as I said, can be a very insurmountable obstacle for some. And it's a very difficult position to be in when you have put your life savings, you have put a sizable investment into a condominium, particularly in a market right now, Mr. Speaker, where it is very difficult to resell and recoup your investment. Now, I understand that the minister said that he's going to set some of these things out in regulation, and that in regulations he's going to require that condo boards will need strong and compelling evidence for charging for damages, as well as a fair way for owners to appeal decisions. On that, Mr. Speaker, I am a bit more hesitant about simply trusting this to the regulations, particularly because there has been work underway for a number of years that was first hinted at in the legislation that was passed by the PC government, was worked on by our government during the 4 years we did the work towards it, and was indeed promised by this government and continued until now to create a condo tribunal. Now, the existence of a condo tribunal would certainly make this an easier change to accept. That owners would have an option outside of having to go directly to the court system or depend potentially on the goodwill of the board as to having a fair appeals process. And certainly, Mr. Speaker, we can keep in mind what this government had attempted to put forward in terms of an appeals process when it came to traffic tickets and some other things in the courts here, where individuals would have indeed had to pay out of pocket and would have been judged more or less as guilty until they proved themselves innocent and having to pay for the privilege of doing so. So I think we have some reason to be a bit hesitant, a bit skeptical about what the government is going to put in place to ensure that owners who are put in this position where they are judged to have done that damage and they are leveled these charges, and that there will be a truly fair option of appeal. And I can tell you, Mr. Speaker, that is one of the things I have heard about most. So I said I've heard from a few folks about the chargebacks. I've heard from many, many, many more about the need for the tribunal. And I can tell you, during the time that we were in government, I repeatedly was reaching out to our Minister of Service, Alberta, and asking about progress on that point. We saw other pieces move forward, other pieces of the regulation, but that was one that, did stall out. It turned out to be perhaps complex. To be honest, I was never quite clear exactly on all the pieces that were involved there, but I do know that we are coming up now on potentially 5, 6 years that this has been in process. And this was something that this government said they were going to get done, and now they are effectively saying, no, we are not. Without a lot of clarity on why. And we know that this exists in other provinces. BC has a civil resolution tribunal to resolve condo disputes of any amount, handles other issues in BC that are under $5,000. It issues fees and fines, deals with condominium bylaws that are arbitrary or unfair. So it provides a much-needed check and balance, Mr. Speaker, on what is essentially an honor system. Again, unless owners can afford to actually go to court and go through that process. And Mr. Speaker, we also know the state of our court system right now. It is under enormous pressure. We know there are cases at risk of not being able to proceed for having exceeded the statutes that have been set out. We know that our Crown prosecutors, and I was thankful to hear today that they will not have to go on strike, but that indeed they have the opportunity to sit down now and enter into a negotiation with the government to address their issues. But certainly, we are hearing from defense lawyers now who are also asking questions about, okay, if there's going to be a change for them, is there going to be change for us? But overall, what we know is our court system is already under enormous pressure. And indeed, that was part of why the government was originally justifying the somewhat troubling and lopsided approach they were looking at taking with traffic courts and traffic tickets, which they have walked back. But the fact is, we still have enormous pressure in that system. And to say at this point then we are still going to leave these kinds of disputes to our court system to resolve is just going to add more to that pressure. So it would be my hope that a government that has said, they are dedicated to red tape, eliminating red tape, making processes flow more smoothly, giving Albertans more access to grassroots democracy, would have prioritized a condominium tribunal, would have put real work and effort into achieving that. Unfortunately, we have not seen that, and that is not in this bill. Ontario also has a Condominium Authority of Ontario, arm's length from government, has a tribunal authority, Condominium Authority Tribunal. They have a $50 levy that goes for all condos and then fees for some of the services, but administered online, and it offers opportunities for negotiation, mediation, and adjudication. Nova Scotia has a condominium dispute officer, a condominium arbitration process. So, Mr. Speaker, there are clearly models that we could be looking at in other provinces. There's certainly opportunities for us to be bringing this forward. And I would be interested to hear from the Minister of Service, Alberta, a bit more about what the obstacles have been to moving this forward in Alberta and why the decision has been made at this point that they're simply setting that aside, that is not a priority. But as I can say, again, for folks in my constituency, it continues to be a priority, and it continues to be a concern. And particularly when we were talking about housing issues and challenges for people to own their homes, certainly we are all looking, I think most municipalities are looking for opportunities to increase their density, certainly for urban living and more opportunities. And we have seen a significant growth in the number of people that are living in Edmonton's downtown, and that then has economic benefits, and that also has good benefits for the city in helping to curb urban sprawl. But the fact is, when we're increasing that kind of density, a lot of that ownership is going to be in condominiums. So we really need to be thinking very carefully about how we can make this a better system, with more accountability and more protection for individual owners, as well as for condominium boards. Because let me be clear, Mr. Speaker, I know I have spoken about boards that act badly or are disingenuous or may target owners, and those exist, but certainly I have also been in the position of working with a number of people who were very dedicated on their boards and dealing with very difficult situations like building-wide bed bug infestations, or indeed folks doing damage to property or other things that can occur. And I recognize that can be very thankless work, and it is done by volunteers for the large part. So by no means do I want to disrespect the folks that step forward, or indeed the folks that have advocated for this particular change from the minister in regards to chargebacks. I think it's just very important for us, particularly as legislators, that we are thinking carefully about the impacts this could have on individual owners. With that said, I think I'm nearing the end of my time. This is my first opportunity to debate the bill, and I imagine there will be more, and I look forward to perhaps hearing from the minister on some of these questions.
Thank you, Honourable Member. Are there any members wishing to join? I see the Honourable Member for Calgary Mountain View has risen.
Thank you very much, Mr. Speaker. And I have a great deal to say about this particular act, but to begin with, I am rising to move an amendment. I'll just wait for that to reach you.
Honourable member, this for the purposes of debate will be referred to as REF 1. As is the normal course of the procedure, if you would like a copy of the amendment, please put up your hand and one will be delivered. There will also be copies at the table. There will also be copies available in the Peace Lounge should you be looking for one there. The Honourable member for Calgary Mountain View, please continue.
Thank you very much, Mr. Speaker. So I move that the motion for second reading of Bill 19, Condominium Property Act 2022, be amended by deleting all the words after that and substituting the following. Bill 19, Condominium Property Act 2022, be not now read a second time, but that the subject matter of the bill be referred to the Standing Committee on Families and Communities in accordance with Standing Order 74.2. So, Mr. Speaker, this is an amendment which is commonly referred to as a referral because it refers the substance of the bill to a committee. And I actually think that that is a good thing to do with this particular bill. Now, I'm not suggesting that all the changes in here are bad, but I think there are a few details left to be worked out. So obviously, one of the things the bill doesn't do is establish a tribunal to deal with these matters. So that's certainly something that I heard about an enormous amount in government. I've heard about it an enormous amount since we've been in opposition. Probably the main ask that I hear from anyone who wants to talk about this act is when will the tribunal be established? And the reason for that is that court processes take a very long time. They're extremely costly. The procedures can seem quite difficult and arcane. It can be difficult for people to understand what the steps are they have to take, or how to argue it, or how to move something forward, or how to get it resolved. So the idea would be to bring in this tribunal to help with that. And I think, of course, of the Residential Tenancies Dispute Board, which does handle disputes under the Residential Tenancies Act significantly more quickly in a lot of cases. And so people find that incredibly helpful. And yeah, I would say the primary ask I get from people representing condo boards, people representing condo owners, just people generally, is about this sort of resolution mechanism. And I think that it would be extremely helpful here because things are often more complicated than they appear, and because, I mean, the really nice part about alternate dispute resolution is if you're doing it right, it's not just sort of two parties who go in and fight and one wins and one loses. If you're doing it right, what happens is everyone comes together and they sort of explain what their feelings are around the situation, what they think happened, and kind of what they would like to have resolved going forward. And it can actually result in better resolutions. So rather than one side or the other side, rather than like very sort of clunky orders that can be provided from the court, it can often be the case that people will sort of negotiate to a resolution that isn't something that ever would have come out of a court decision, but is something that is better for all of the participants involved. It can happen faster, with a lot less sort of stress and turmoil and cost for everyone involved. So I really think that that is something that should be moved forward to. I know this government had committed to that in the last election. I'm sad to see they didn't move forward with that. They moved forward with a lot of commitments I don't agree with, and just so happens, I guess the one that I did agree with, they didn't. So there we go. The other, I think, concern here, and my honourable colleague who spoke before me raised it as well, is the chargeback system without an obvious mechanism to create that accountability. So I think it's worth sort of starting with a story, because, you know, these situations can be incredibly complicated when you come right down to it, right? A lot of condos, for instance, are rented out. So it can sort of create a complicated scenario. So in this scenario, you have a tenant, and the tenant has received notice that there's some sort of leak from the washer. It's believed the pipe is backing up or something like that. They ought not to use the washer in the interim. That's fine. Now, the property manager will only speak to the owner of the unit because, well, some property managers are very good and others are not very good, and the one in this story is pretty abysmal. So the property manager sends a plumber. The plumber comes, the plumber talks to the tenant, says the pipe is backed up. It's full of built up laundry detergent gunk, just a bunch of gunk. It needs to be snaked. It can't work until it's snaked. Okay, fine. And then the property manager, because they know that it is a condo which is inhabited by a tenant, just really doesn't bother to get around having the plumber come back. And they don't have to deal with the tenant, so of course not their problem. So roughly somewhere between 5 and 6 weeks elapse, and the landlord, feeling a sense of obligation, because decent fellow, comes and does it himself, snakes the pipe himself, and says to the tenant, okay, great, the problem that the plumber identified has been solved. You may now run the washing machine, which the tenant does. Well, turns out that never was the problem. Not really clear what happened. Perhaps the plumber was mistaken, or who knows. But anyway, that's what happens. The result is that the thing leaks again. Turns out that the actual problem is there's a hole in the pipe, but the pipe is behind a wall. And so, considering this an emergency, the condo manager person, who of course will not talk to the tenant who inhabits the property, sends someone in and drills a giant hole in the wall and leaves a big mess and doesn't check for asbestos and is just generally extremely problematic. And so the tenant obviously reaches out to the landlord and says, I would like some assurances that this giant pile of mess that's been left for me to clean up is not in fact full of asbestos. And no one is able to provide that assurance. And so it goes round and round and round and round. And this has never been resolved, to the best of my knowledge. I guess I haven't been involved in the situation in a while. But the point is that if the condo corporation, on the word of this manager, chooses to charge back the unit owner or the tenant in that case, there is very little ability for those people to defend themselves. Despite the fact that I think from the story it's fairly clear who is in the wrong, and it is the manager. But the manager isn't going to tell the condo board that they're in the wrong, are they? So it just creates a situation where potentially people are being charged with something, and now they have to pay an enormous amount to defend themselves in court, which can be a lengthy process, and the money can be in dispute for a long time. So this is, in my view, not an ideal situation. And this could apply to any situation, because the way this legislation is drafted, so this is amending legislation. It repeals and replaces Section 39. Subsection 2 allows the chargeback to be levied for damage. 3 says it must be actual costs. Sub 4 says costs or the deductible from the insurance, which is a whole different issue. And 5 says can dispute in accordance with the regulations. Well, I don't really think that's good enough. If you're that tenant, and you know, this is the other thing, a lot of people who are tenants in condo buildings who are potentially subject to this, who are potentially being charged with this, being charged by these condo corporations, may be young, right? They may be students, they don't have a lot of money, they don't necessarily know how to seek legal advice, they could be people who are new to the country, English is a second language. So it puts them at a disadvantage. It puts them in a position where they are essentially guilty by way of charge from the condo owner until they prove themselves innocent. And I think that is a problematic way to go about it. Now, I certainly have heard that there are concerns around the process now. So it is very hard. If someone is willfully causing damage or willfully being problematic, it's incredibly hard to go after that person for a condo board. And that's problematic. It's difficult to get people to serve on condo boards for a number of reasons, because it's not compensated and it's a lot of headache. If you have some finicky people who are disagreeable, which is sometimes the case, it can be, an unpaid sort of headachy problem. So certainly this is a problem that needs a solution. I'm just not sure that this solution is the best solution. And the reason is that instead of putting a condo board in a position where it has this real big problem, where it has to go after someone and it's procedurally onerous, now you have either the owner or the tenant in that position, where they're charged until such time as they can prove it wasn't them. And now they're having to go through a procedurally onerous situation. Now, this government says, don't worry, there'll be lots of protections in the regulation. It's worrisome, right? It's worrisome, obviously, because we've heard this a lot. Don't worry. Public health care guarantee, don't worry. And it often isn't the case, right? It's very easy to promise up front and not follow through. This government has a long and demonstrated history, I would say, of promising things up front and not following through. But this amendment gives us the opportunity to take the time to do the due diligence and the due consideration. Because I think, they can dispute it in accordance with the regulations isn't quite enough. It's not enough protection to make it clear what's going to happen. And again, yes, these changes needed to be made because currently the system is unfair to the condo board. I feel that this solution, rather than balancing things, just shifts that unfairness to the other party. And that's not the right way forward either. So what could happen at a committee like this is that, people who have been through these situations could come forward. Lawyers who are familiar with the area, people who are familiar with condo governance could come forward, and everyone could sort of explain what problem we're trying to solve and come up with a better solution, because I think there are better solutions than this. So yes, I guess I would say this is a problem. It needs a solution. I don't particularly like this solution. I think we ought to go to a committee and sort of discuss what a better solution might be. And I think, Mr. Speaker, that a better solution might itself hang on the tribunal that has not been implemented, because I think that is the system that could make everything a lot faster. It could adjudicate rights and interests. We have this concept in administrative law that the sort of level of procedure to which you are entitled is proportionate to your interest in the matter. I actually think this is a really good principle. I think it should flow throughout the entire court system. The idea that oftentimes, functionally, someone who is fired from their job has basically sort of, they can go to employment standards, but that only gets you the minimum, which is quite low in many cases. Functionally, there isn't much they can do through the court system. So functionally, they can't challenge that. Meanwhile, if you get, a $75 speeding ticket, you get sort of the full court press for that. I don't know that's the best way to do those things. And so I think a tribunal might solve some of those problems. It might make it the case that we can kind of deal with these issues faster and with the amount of procedure that is necessary to handle what it is that is coming forward, so what the particular dispute is in this particular instance. So that is why I think it should be referred to a committee, because I think that the committee can do the difficult work of assessing assessing exactly what a better solution to this, genuinely giving the government credit here, problem that needs solved is. And I guess the other thing I would say about this bill is that it really does need that tribunal attached to it, because I think that that is probably, that's probably the number one ask. I don't think I've ever heard a different number one ask from anyone involved in condos in any sort of position or in any way. So that would definitely be a good thing. Potentially the two things are linked, potentially the one thing goes with the other. It would be interesting if the minister could tell us a little bit more about the regulation. They're saying, don't worry, it'll be in the regulations. That's fine. I feel like I could use a little more information about what would be in the regulations, a little more information here in this place on the record, so that there would be sort of a record and an accountability there. An accountability to ensure that those things were followed through, and to reassure the concerns of the opposition. I don't think, I think it's pretty normal in this place for people to ask these sorts of questions, to ask for more details, to ask for that sort of thing. And I think it's not unreasonable for a minister to come forward and provide those additional details, to make sure that everyone's understanding, I guess, where we are and how we're going to proceed, forward. It certainly has been the case, at least in a few instances. Oh, thank you.
Thank you, Honourable Member. We are on REF 1. If there's another, I see the Honourable Member for Edmonton McClung has risen to debate.
Thank you, Mr. Speaker. Pleased to rise this evening to speak about REF 1, referral amendment to the Condominium Property Amendment Act. Always interested in delving into real estate matters in this House when questions of changes to legislation regarding the sale or regulations around the ownership of real estate are considered. And, of course, this piece of legislation is no exception. And I do agree wholeheartedly, Mr. Speaker, with my colleague, member for Calgary Mountain View, who recently just spoke now about the reasonableness of having this piece of legislation referred to committee so that many unanswered questions can be addressed by committee members and perhaps those who the committee could call before it. I know the member for Calgary Mountain View was quite detailed in her approach to the legislation and the need for having the committee consider it, and I hope to add to some of her arguments with a few observations of my own, Mr. Speaker, some of them coming from numerous years selling real estate and also acting as a real estate brokerage sales manager, and having to face the ire of buyers and sellers who would be phoning myself to help resolve disputes that they may be having with their unit after the fact or upon inspection, and finding out that there were issues of concern that they were now being stuck with that they didn't feel they should be held responsible for. And of course I speak about the concern that many condo owners have had, and some continue to have, regarding the windows and doors and the weatherproofness of them. We've gone through a period of time within the last decade and 2 decades perhaps where there was a problem with the so-called leaky condos, Mr. Speaker. And it wasn't something that was limited to British Columbia, where indeed they have more rainfall on the coast, and it was a widely spread concern and costly issue that arose there. But it was right across the country, and for that matter, Mr. Speaker, throughout North America. And it arose because of faulty workmanship and or design in the condominium doors and windows in particular, not so much the roof, but sometimes that roof cap was also the culprit as well. But I'll refer specifically to the condominium windows and doors for my comments on this topic, because what the legislation does, Mr. Speaker, is move the definition of windows and doors from regulations into legislation. And I understand, I think, the motivation of the minister for doing this, because it is an extremely contentious thing to a condominium owner who is faced with the prospect of a major bill to repair damage in their own unit, or a unit that happens to be directly below them as a result of water leaking from their unit to the next unit, but also to between the condo unit owner and perhaps the tenant of that condo unit owner and the condo corporation itself, because common property may have been damaged. And Mr. Speaker, one may think that perhaps fire is the worst cause of damage claims to property and the worst threat to property, but realistically, water is by far a more insidious and sometimes silent destroyer of property, and it can happen slowly and over time and be imperceptible for months, in fact for years, until for some reason mold is discovered or a weakness in the structure is discovered, and it's an insidious invader of property, particularly where wood is involved, but in any case where water can penetrate the surface of a building material, stay for a while in proper temperatures and proper conditions, and grow into a moldy condition. And it can be unbelievably expensive to fix, requiring, in some cases, near total reconstruction. In some cases, Mr. Speaker, we've heard about particularly houses on acreages recently just west of town around the Spruce Grove, Stony Plain area, where the houses were condemned as a result of mold. And that can happen if it's not addressed. But it's a really difficult issue and a really difficult problem. And I'm concerned that the legislation requires that the definition of responsibility for windows and doors has been relegated to legislation from regulations. And I'd like to hear more in committee, should the referral amendment be successful, about the reasoning why the minister thought that this would be a good methodology to correct any lack of clarity around responsibility for damages caused by leaking windows and doors. It is a rather rigid tool to have the definitions of something as minute as the door trims and casings versus the window trim on a constructed opening, to have that embedded in legislation rather than in regulations, which would be by and large more flexible should things change or should there be developments in case law which suggest an alteration in the regulations would be wise to do. Yet here it would, of course, should there be that case law arise, it would require opening up the Act to start playing around with definitions of window sills and window doors and balcony trim versus fascia versus the casing. And I just don't quite understand the need to embed all of that definition, that minutiae, into legislation when in fact it probably would have been a bit more nimble to have altered regulations and made it clear that notwithstanding what a condominium corporation may have said, if indeed they're undefined, then the regulations would define what the opening or what the windows and doors, what responsibilities were whose in any particular case. So that question I think we deserve a satisfactory answer to in committee should the referral amendment be successful, because the issue is not tiny. We have had millions and millions and millions of dollars of claims and counterclaims because of leaky windows and doors in condominiums in Alberta and throughout the country. And they are very, very difficult situations to be in, where you will have had, in some cases, condominium corporations do a cash call, in other words, a charge to every unit holder to rectify faulty windows and doors that were either a design flaw or perhaps workmanship issues when the building was constructed. And of course, they usually weren't discovered until the responsibility of the builder and the designer and the architect was long since expired. So it became part of the responsibility of the owners to combine their resources and fix them themselves. And in many cases, the condominium corporation itself was responsible because there would have been common area doors and common area windows that would have suffered the same design flaws or shoddy workmanship and had to have been repaired as well. But the idea of embedding the minute definitions of windows and doors into legislation rather than allowing them to stand within regulation is something that I still don't quite see the need for, and I'd love to hear more from those individuals who've been directly affected by a situation where they had to face the onerous cost of replacing or repairing windows and doors in their unit or in a common area of a condo, could come before the committee and explain exactly why they think it would be beneficial to have this definition embedded into legislation versus maintaining it in regulations. So I know that you'll have quite often, Mr. Speaker, a contiguous line of people suing each other when it comes to a rented property, and the tenant is perhaps responsible for damage, and particularly, as I said, water is the number one, but there could be a number of different damages, and you know the insurance industry is replete with circumstances that would be beyond belief unless they actually happen to you. But there's any number of circumstances that can happen when an individual is living in a condominium and they have a pet, or they have a child science experiment go wrong, or it can simply be water damage or perhaps a small fire. I know that there's situations where even in some of our public-owned housing, the tenants are being evicted for having caused a fire, and that's something that concerns me. But in this particular case, a tenant responsible for damage, quite often in the rental agreement, will be required to provide proof of a policy of insurance to a certain amount for certain insurable losses. And I'm not sure if the legislation before us contemplates that requirement. Of course, mortgage companies require that a property be insured, so that, of course, the mortgage company insists that it be in first place to receive the payout of that insurance, and that's part of the mortgage contract. So that's something that we can also discuss in committee, Mr. Speaker, that in the event of losses from an unintentional but insurable loss or consequence, the tenant, in fact, could be required by their landlord to have insurance which would protect against as much of potential liability as possible. And not only that, of course, you would look at that being in the condo bylaws, but the owners would hopefully also be required by the condominium corporation bylaws to protect themselves with adequate insurance against chargebacks that might happen as a result of their liabilities towards the condominium corporation in the event of water damage or something that the condo claims is the damage caused by the condominium owner in that particular complex. And in that particular case, of course, if there's a tenant involved, there may be a suit back through to the tenant from the condominium association. It can be a true minefield of pain and agony if indeed it gets to a situation where individuals are suing one another and attacking one another in court to recover their perceived damages. And that's all the more reason, Mr. Speaker, why it's important to consider having this legislation considered in committee, because of the responsibility, I think, of this legislature to make sure we avoid the courts, the onerous costs and time liabilities imposed upon condominium owners, in this case, if they have to go to court to resolve disputes. And the other big issue that we've heard many members comment on from our side of the House, especially issue that we have with this legislation, is the dispute resolution void, let's say. There's no opportunity for an owner to actually avoid the courts because their tribunal wasn't brought forward. It was contemplated in the regulations that we brought forward when we were government, when we had the Act open, and the UCP current government did not follow through with it, and unfortunately didn't, in this version of their attempt at changing the legislation for the better, has not seen fit to bring forward a tribunal that would allow condo owners, tenants, to avoid going to the courts to seek redress. And what it does, in my view, is empower a condo corporation who will have more resources and therefore more power to pursue their interest in court. It gives them an advantage versus the individual owner of a particular condo unit. And as a result, you'll see perhaps unit holders not wanting to engage in court action and just simply suffering a loss, or perhaps claiming bankruptcy. Because that's one option that a person doesn't see as a far-fetched thing to pursue when you're owning a condominium and it may be $200,000 or $300,000 or $400,000, and you're ending up facing a claim from your condo association in the same amount. So it may be pretty unreasonable to proceed with anything other than tribunal.
Member, are there any other members wishing to join? I see the honourable member for Calgary Buffalo has risen.
Thank you very much, Mr. Speaker. On the referral motion, I do wish to join debate and follow my colleague from Edmonton McClung, and similarly agree that I believe that we should not read this bill a second time, but refer it to the Standing Committee on Families and Communities in accordance with Standing Order 74.2. And standing up and following my colleague from Edmonton McClung, I think from earlier debates, I understood that he's worked in the real estate industry for 30 years now and seen his fair share of both positive experiences, no doubt more positive experiences than negative, but certainly can't have a 30-year tenure in real estate and serving Albertans with their sale and resale and the challenges that they had, some of those have with regard to their purchases or tenure in their properties that they bought through this individual being a real estate agent. So with lots of experience on his side, his previous debates, he's talked about some of the challenges that we have before us as a result of this bill coming forward and the way it's come forward. And my colleague from Calgary Mountain View is proposing that we go to a committee, refer to a committee, for the opportunity to hear more from people who have seen this bill and perhaps judge it in a wanting way. And I know from my previously the member from Grand Prairie, and I think introducing this bill for the second time, perhaps on behalf of the member or the Minister for Service Alberta, talked about how there were regular meetings with groups of dedicated representatives throughout 2020 and 2021 that Service Alberta held. And just thinking of some of those individuals, whether they be representatives from community groups representing condo owners or boards or managers of condos, lawyers, all of that would be a really useful group of individuals to hear more from, and to kind of understand their views with regard to what came forward in Bill 19 and what is left up to regulation. Just thinking about the growth of condominium ownership also in Alberta from 2020, one of the documents I was looking at said 2011 to 2016, from CMHC, said there was a significant growth in condo ownership in Alberta at that time. Some just thinking back to what those years were like, it was prior to the world crash in the price of oil in late 2014, 2015. So there was a lot of positive growth, positive feelings, positive GDP.
Good vibes.
Good vibes in the province, and so there was a huge percentage of homes built in those days that were condos. And if I think back in terms of a story, though I have owned two principal residences in my time, and currently in the second one for about 36 years, there was a time when my spouse and I owned a condo just not very far from here, as she was working up here at the U of A, and wasn't comfortable renting somewhere, wanted to be in a place we could call our own and lock the door, and it was a nice place. But some of the challenges that we had as condo owners and were around the common property. Though she felt totally fine being in the place, from time to time the elevator didn't work, and she didn't feel comfortable in some of the hallways that she had to go through to get to the unit. But did you use a realtor? Yeah, we use a realtor. The other thing I just wanted to say with regard to all of that is that there were challenges with the ownership. Not particularly, we weren't there that much. She wasn't there that much, but there were disputes, and I recognize what we're dealing with and hoping for is that it'll go to committee, and there'll be an opportunity to talk more about why the tribunals did not get into this bill, though it was very much the plan back in 2015 to 2019 when we were government and we were working and opened up the Condo Act twice when we were government. And there won't be a million different times to open up this act, and hopefully, together we can get it right, and it can service condominium owners for many years in the future. But it means that we need to get this right, and that's another reason to consider going to, hopefully, a referral to this committee that I'm talking about. So just wanted to talk about a few other things in terms of the referral to this committee. As I said, it was very much the NDP government's plan to make sure this act worked for the long term, and the tribunal was something we heard about. And unfortunately, when the new government came in, like many things, there was a desire not to move forward with some of the common sense approaches that we as the NDP were trying to put into legislation. Like, for example, and it's just a quick example, the investor tax credit that two investor tax credits that we brought in as a result of chambers of commerce throughout the province, notably Calgary, making that recommendation and saying that it would attract capital from Alberta investors. And it did. It was a really good thing, and it was unfortunately killed by this UCP government when they became government, but saw the wisdom of changing that in about 2 years after it was killed, to bring in their own, which it's very much the same thing that was in place. So delaying for 2 years the ability of Alberta investors to get credits for their investments and continue to drive forward the economy in this province at a time when we were in the COVID times it seems like a bad thing to have happened in Alberta. But so just another example of what I think needs to happen is we need to take good ideas from wherever they come and work together to make them happen for Albertans. I think, Mr. Speaker, I understand that I should be looking towards adjourning in a second, and I'll take my place, but hope that members of this House will give good thought to and consideration to the referral that we're talking about here. And with that said, Mr. Speaker, I would like to adjourn debate on the referral amendment that I've brought, or it's been brought forward by the member from Calgary Mountain View. Thank you.
Thank you, Honourable Member. On the motion to adjourn as proposed by the Honourable Member for Calgary Buffalo, all those in favour, please say aye. Aye. Any opposed, please say no. That is carried.
Under Government Bills and Orders for second reading, Bill 11, Continuing Care Act, debate adjourned on amendment. Mr. Williams speaking.
Thank you, Honourable Members. Are there any members looking to join debate on Bill 11, Continuing Care Act? We are on REF 1. I see the Honourable Member for Edmonton Glenora has risen.
Thank you very much, Mr. Speaker, and to my colleagues for the debate so far this evening. Interesting, respectful, good questions posed, I think, so far. So I'll do my best to continue in that thread. And the bill that we are considering at this point is Bill 11, the Continuing Care Act. And I have to start by saying that I'm quite familiar with the legislation that governed continuing care and presently still governs continuing care in this province. And I know there are a number of different pieces and that this bill appears to be bringing it all under the same umbrella. And what I want to say is that not all care is equal in this province. And for good reason. There's a differentiation in terms of the needs of patients. Often we're thinking about seniors, but it's not just seniors. There's certainly many folks with significant illnesses who can no longer stay safely, independently living at a certain point. And I can't help but think of the number of young people in this province, many who live in congregated sites and in some type of continuing care. And the fact that one of the things when we were in government that I was proud to bring forward was a bill to ensure resident and family councils at all facilities that were providing healthcare services of some sort. And it really came from feedback from many folks throughout the province that there were some exceptional operators that were doing a very good job of making sure that the residents' voices were heard, that family members had an opportunity to engage and to give feedback and to be advisory to the operators of the facilities that their loved ones were living in. But the operators that were engaging in that space were doing sort of the, probably a reading of evidence that showed that people have a higher quality of satisfaction in life when they feel like they are involved in making decisions about their home, and also out of the goodness of their hearts, really. There was no legal requirement for them to ensure that sometimes these people were incredibly young adults, and sometimes they were quite elderly, but everyone deserves an opportunity to give feedback on their home, to make sure that their home is a place that they can feel a sense of pride and comfort and belonging. So I was proud that that bill came forward, and I believe it ended up with support from, at that time there were multiple parties in this place, I think 4, and I believe all parties did indeed support that bill. Gesundheit to my colleague across the way. But of course, this is one of the questions that we continue to have is with the alignment of all of these pieces that presently govern continuing care, are we actually going to see an erosion of some of those additional pieces that were put in place to ensure that the voices of folks who live in congregated care have an opportunity to give timely, ongoing feedback to the operators of their facility? So some examples I'll share from my lived experience as a granddaughter of somebody who was in long-term care not far from here, the Edmonton General Hospital. When my grandma moved into the General, it was a very, very difficult time for her and in turn for our family because she was one of the toughest women you could ever meet. She was widowed in her 50s and continued to live on the farm independently. When my grandfather went into hospital and was clearly palliative, that's when she said, well, I better get a driver's license because I'm going to need to get in and out of Westlock to go visit him. I'm going to need to be able to continue to live on the farm. She wasn't going to let the fact that her life circumstances and his life was coming to an end hamper her independence. And you know, that at that time was not common for a lot of women to have their driver's license and be able to have that level of independence. And then he did pass, and she continued to live on the farm and run the business of farming for many, many years. In fact, I believe she lived there for more years as a widow than she did as a wife. And to move from the farm into the city was a big adjustment for her. Thank goodness she had some time to adjust to condo living, thinking about the last bill, to condo living, and but still was living independently. And then, of course, at a point, she wasn't able to cook for herself in the way that she once did, and we needed to rely on the community supports of things like Meals on Wheels to ensure that she could have regular, timely meals, because not all of us were able to check in on her as frequently as she should have. But there hit a point where both her body, it was really her body. She had Parkinson's, and she wasn't able to live independently in her own condo. So she moved into a lodge, right? This is sort of the natural step that, for those of us who are lucky enough to live well into our 90s, which my Baba did, this is often the progression of care. But there hit a point, even in the lodge, where there was cleaning, there was cooking, home care came in to make sure she was taking her medication and to help her with morning and evening routines. But she couldn't get up on her own. She couldn't actually transition from bed to the walker to the dining room. And after, I think there was 1 week where the ambulance was there multiple times every day and multiple times one day, it was very clear that it wasn't something that could be sustained because, of course, in lodges, there aren't people who can provide that medical assessment and make sure that you haven't injured yourself. So she spent months in the hospital. And this, again, was when I was quite a bit younger. I was an adult, but I was not the health minister at the time. She spent time in hospital and eventually transitioned to transitional housing through Norwood and then eventually to the General. A difficult journey for a woman who spent most of her life living alone, continuing to farm, and caring for others. A very humbling experience. And when she did move to the General, and I want to say that the staff there, I think, work very hard to, number one, care for the people, make sure that they're safe and that they're not being put at risk, and also to make sure that they have an opportunity to continue to live there. And I remember my grandmother saying to one of the care workers, I'm not here to die, I'm here to live. And that was a really difficult day, I think, for all of us, because so often when people end up in that highest level of care, highest level of continuing care, their time in those facilities isn't very long. But my Baba persevered, and she continued to fight and lived quite many years. I think she was there 5 years at the end. And one of the things that I think helped her keep going is the fact that she knew that my mom and I were going to the Resident Family Council meetings, and this again was one of those facilities that was an exception, that didn't follow a rule but had set this up because they have hundreds of residents, and it was a way to help streamline feedback and shared processes. And there were simple things that she wanted us to communicate, like she didn't want them to bleach her blouses, right? Like simple things about laundry, something that she'd done for her whole life and taken pride in. She wanted to make sure that less harsh chemicals were used on her nicer pieces of clothing. She didn't want to have to downgrade her wardrobe because of the laundry provisions there. These are the kinds of things that right now under the Resident and Family Council Act, we have an obligation for people to receive that feedback. And in turn, we came up with a system where we'd have 2 different laundry hampers, and there was one that my mom and I would take home and the other one that the facility would deal with. We could problem solve some of these situations. Also, there were many residents who live there on the 5th floor who are Chinese and have Chinese news, Chinese television, and they wanted quality Chinese food in their long-term care, in their residence for the long term. They wanted to have good quality Chinese food that was prepared locally. So giving feedback on the congee, giving feedback on the other dietary options that were available or not available was incredibly important to them. And not everyone was it a family member who would go. There were some people who were quite young, who had conditions like MS and weren't able to live independently anymore, who would go and talk about the types of quality social activities they wanted to have. Bingo wasn't high on their list of desirable activities, but there were other fun, more youth-focused socializing activities that they wanted to have available. So they were able to communicate that collectively through these spaces. Some of my nervousness around this provision to one act to govern all care facilities exists because of the severe needs that we see in long-term care and in dementia care specifically as well, that we are going to be governing under this blanket legislation that will probably bring things to one standard as opposed to differentiated care. And one of the things that right now long-term care is essentially a hospital. It's governed by the Hospitals Act in a large way, and there are provisions for hospital care that the residents of long-term care are entitled to. For example, you do not pay for your medication. It's part of the Canada Health Act umbrella of services that's available to you when you are in a hospital. So those who are living in long-term care have their medications fully covered while they are living there. That's not the case in other levels of care. Even if you're a senior and you're on the senior's drug plan, you pay $25 per prescription to receive the medication that you need to stay alive and to stay well. Another big difference is that in long-term care, there is a requirement for a registered nurse. Essentially charge nurse who must be a registered nurse to be in charge of the provision of care. And in large centers like the General, there might only be one for hundreds of patients, but there is at least one because of how they are governed and how they are legally required to provide that level of professionalism and care. But it is not the requirement in other lower levels of care necessarily, Mr. Speaker. So making sure that I get that we want to have one bill to govern them all, but the challenge is that not everyone's needs are the same. Somebody who is in a level 3 facility technically needs to have a lower level of care and lower level of supervision and guidance. So, Mr. Speaker, making sure that we have legislation that differentiates to patient needs and those who are living in higher level of care being entitled to the provision of medication and the provision of a registered nurse, I think is important. And I fear, because most of this detail, the minister and others might say, will be ironed out the fine details will be created through regulation, which means the government is saying, just trust us. Trust us that we will make decisions on all of the details that relate to this bill behind closed doors. And I have to say, there is an incredibly low level of trust right now between Albertans and their premier, between Albertans and the governing party. And there is this request to trust just isn't there. So as members of the Her Majesty's Loyal Official Opposition, we have a responsibility to push for verification. And because we do want to be able to trust, but it has been so significantly damaged by many decisions that the current government has made over the last 3 years. And of course, healthcare has highlighted the lack of respect the current government has shown to healthcare workers, as well as to those patients who rely so significantly on daily care, especially towards the end of life. When I think about the number of people who have died in Alberta directly because of COVID-19, not even to think about all of the indirect fatalities, but directly because they had COVID-19, knowing that about half of those lived in buildings that will be governed by this legislation. About 1,600 continuing care residents tragically passed away from COVID-19. And at the very beginning, you saw a significant call to action, and the government even did make some slight changes. For example, it took months, but eventually they said, yes, you should only be working in one facility. You shouldn't be working in multiple facilities. Of course, anyone who understands disease, infection, and how airborne diseases that are highly contagious spread, of course, staff should only be working with one group of patients. They shouldn't be moving from facility to facility to facility. But because of the way so much privatization has taken place under Conservative governments, we saw that there were many staff, the vast majority of staff were working in multiple facilities.
Thank you, Honourable Member. Next, I see the Honourable Member for Spruce Grove Stony Plain has risen to debate. On RA1, I was mistaken previously. I said that we were on REF1. We're on a reasoned amendment, not a referral amendment. I am looking for anybody to join debate on RA1. I see the Honourable Member for Edmonton City Centre. Thank you for that.
Thank you, Mr. Speaker. Appreciate the opportunity to stand and speak to RA1 on Bill 11, the Continuing Care Act. I'm going to pull up that reasoned amendment here just to give myself a bit of a refresher of the specifics to which I'm speaking. That the bill not be now read a second time, because the Assembly is of the view that the government has not carried out sufficient consultations as to the content of the bill with the families whose loved ones lost their lives from COVID-19 while in continuing care. Now, certainly, Mr. Speaker, I appreciate that Bill 11, as has been presented, is largely an administrative piece of legislation, focused on consolidating bills and regulations, making some few administrative updates, taking what's been spread across a number of different acts and combining it in one. My colleague from Edmonton Glenora spoke to that, raised a few concerns potentially with what could impact from that, and certainly I would agree with her that we need to be careful that in consolidating the legislation, we are not making assumptions that all kinds of care that are captured here under this act, this new act that's being created, should it pass this Assembly, because indeed we recognize that there are very significant differences between the different levels of care and certainly the needs of the individuals in between each. Now, certainly I recognize the importance, Mr. Speaker, of laying out framework, making sure you get that framework right, laying your foundation before you begin to build. An excellent quote that I ran across just recently that appealed to me very much is a guy that's very much a systems thinker, was from author James Clear from his book Atomic Habits. You do not rise to the level of your goals, you fall to the level of your systems. So it is really important to get frameworks right. Get your systems right, Mr. Speaker, if you want to achieve your end goals. And certainly that is one of the things we have continued to hear, I think, from a number of Albertans, and in particular in referring to RA1 here, where we are talking about the impacts on families who lost loved ones during COVID-19. Certainly, we need to think very carefully about the results we are getting. And based on those results, what the concerns are with the systems that are bringing us there. So certainly that was the focus of the review that went into this and the work that was done by government and the report that has come forward, making a number of recommendations on changes that need to happen within our continuing care system. The facility-based continuing care review report that came forward. And certainly when we are specifically talking about families who lost loved ones during COVID-19, there are some very specific recommendations that came forward as part of the FBCC review that indeed are not represented in this legislation, but I think have a significant impact on the work we need to do to improve these systems. And many of those have to do with, as my colleague from Edmonton Glenora was speaking towards the end of her remarks, have to do with staffing. So amongst the opportunities for improvement that were listed in the FBCC review, we're increasing the direct hours of care for nurses, healthcare aides, HCAs, therapy staff. So certainly that is something I've heard from many, many people who have come to me with concerns about the care that their loved ones have received or situations that have arisen within the continuing care system, is concerns about the number of hours of actual care that are going to individual residents. And that in numerous situations due to short staffing, and that for various reasons, whether that's due to some facilities that were looking to cut corners or save dollars, or just whether that was due to pressures with, unfortunately, staff being ill and not being able to keep a full staffing complement, that they found there were situations where indeed proper care was not being provided. So there were not enough hours being provided for people to be toileted, for them to be helped with getting to meals, being helped with eating their meals. And that led to concerning situations for their loved ones. Some of the other opportunities for improvement that are listed: improving mental health and wellness supports for staffing, increasing the level of full-time employment opportunities for some positions, enhancing the working conditions for staff, wages, benefits, workplace supports, training opportunities, and empowerment. And that speaks directly, Mr. Speaker, to the topic of this referral amendment, which is saying that what we have learned from the COVID-19 pandemic and the effect it has had on the loved ones of many families in Alberta is that these have been some of the most significant factors and were exacerbated, highlighted during the COVID-19 pandemic. Increasing the level of full-time employment opportunities for some positions. Indeed, Mr. Speaker, we know that during the COVID-19 pandemic, one of the biggest issues was that staff, as we've talked about many times in this House, staff that work in continuing care facilities often are unable to get enough hours or earn enough at a single job due to low wages, due to an unwillingness of some of the facilities to offer full-time hours, because then you're able to save money because you don't have to pay benefits. But that creates in a situation like a pandemic a problem, because you do not want people working in multiple facilities when you have a virulent infection spreading in the populace. That's a very quick way for it to hopscotch, jump its way between one facility to another, and indeed we saw that happen. So steps had to be taken by government, and certainly it was an issue that we raised as an opposition a while before government took action. And certainly it took some time for that to be implemented and put in place, but eventually that was one of the things that was arrived at And as part of that, there was work that had to be done then to try to determine, well, how do we make these workers whole? So if they have someone who's been working 3 part-time jobs and now they're going to be restricted to a single facility, how do we ensure that, in fact, they are going to continue to have the hours they need to be able to earn a living? So certainly I think that is a very real concern, something that deserves to be considered, something that deserves action, but something of which we see no mention in Bill 11. And indeed, at this time, we have no indication of what the government intends to do in that regard, or what steps they might take. Now, the minister says those are things that would take place in the regulations, and indeed, the former Minister of Health talked about that being a process that would take place over the summer and would be coming back in the fall. And we don't have much information on what the plan is there, Mr. Speaker, which is one of the reasons for the referral. Take the opportunity to better get a sense of what action the government intends to take on that particular point, as it impacts very directly the experiences of families who lost loved ones during the COVID-19 pandemic and are very invested now in seeing real improvements to the system so that others do not find themselves in the same position. Improving mental health and wellness supports for the staff and enhancing their working conditions, 2 pieces that are very closely related, Mr. Speaker. Now, certainly we know that these are very real and pressing concerns throughout our healthcare system. We continues to be under enormous pressure. Healthcare workers in general, in our hospitals, emergency rooms, ICUs. Across the system, Mr. Speaker, our nurses, our doctors, our various care providers are exhausted after multiple waves of the pandemic, and unfortunately many decisions by this government which push them to their absolute limits. Continual choice to act last and act least. And the very real impacts that has had on their mental health, their physical health, and indeed leading to the critical staffing shortages we continue to experience across the system, including at times in continuing care. So again, when we were talking about this referral, saying that we believe that this should be set aside for a time and not proceed through second reading, because there is missing here that consideration of these impacts for the families who have lost loved ones due to COVID-19, and indeed their advocacy for improvements in the system, Mr. Speaker, so that we can achieve the goals that we say we have set. Certainly amongst them needs to be looking very closely at increasing the level of full-time employment opportunities, improving the mental health and wellness supports for those staff, and indeed their access more broadly to benefits, which is closely related to the level of full-time employment opportunities. And indeed wages. And Mr. Speaker, I recognize, of course, that this government has, made great efforts to try to grind down wages for many healthcare workers. Certainly we saw that with nurses going into the fourth wave, the fourth wave, Mr. Speaker, where the government was demanding 5% wage rollbacks. And certainly we've seen their position now, which HSA, respiratory therapists, paramedics, a number of others, demanding wage rollbacks of up to 11%. But a failure to understand, Mr. Speaker, what is intact here in their own FBCC review, and I think again pertains to this referral amendment. And the fact is that if we are lowballing the wages of healthcare workers while at the same time grinding them down with the conditions, that is going to have a direct impact on the quality of care provided. So these are definitely, I think, serious considerations, and I think Albertans deserve an opportunity to have some discussion of that as we have Bill 11 here in the legislature, despite the fact that it is largely an administrative piece of legislation. I think Albertans are looking for a little more meat on the bone. And again, we have promises of what's going to take place during the regulation, but I think as I and my colleagues have noted on many occasions, there is a government that has burned an awful lot of trust. Particularly when it comes to the healthcare system, Mr. Speaker, I can tell you, when I'm knocking on doors, when I'm making phone calls, both here in my constituency and in many in Calgary and other parts of the province, this is a top concern for folks. When they tell me they do not have trust or faith in this premier or this government, healthcare is at the top of the list. So I think we are simply doing our due diligence as an opposition here in putting forward this referral amendment and noting that there is work that needs to be done to earn the trust of Albertans that the actions this government intends to take on ostensibly improving the continuing care system are indeed going to be substantive and are going to address these very real concerns that go to the heart of the issues in the system. And in general, Mr. Speaker, I would say the treatment of healthcare workers in this province over the last 3 years under this government has been absolutely shameful. From doctors who certainly are able to earn a reasonably good living and are in a position to be able to advocate for themselves, and they certainly have, Mr. Speaker. They've spoken up loud and clear in terms of their concerns with this government. Through nurses and other systems, down to these folks who, in many respects, Mr. Speaker, are at the bottom of the system, have the least strength in terms of advocacy, have been the ones who have been least likely to have their voices heard, indeed, because many of them come from marginalized communities, many of them racialized workers, Mr. Speaker. Indeed, many of them of the sort who were misunderstood at times and blamed for the spread of COVID-19 amongst their communities, when the fact is they were put in a far more vulnerable position because of many of these exact factors that were listed in the FBCC review report. The fact that they were precariously employed, that they were low wage, they had no benefits, were unable to get full-time hours. And indeed, Mr. Speaker, if we had a collection of race-based data here in the province of Alberta, we would have more evidence on that front about what those impacts were, as they have had from Ontario, for example, where they have passed such legislation. But the fact is, even without that concrete data, we are well aware, from speaking with those individuals, from speaking with the folks who are elected to represent them in the labor, about what these impacts have been and what the need is. And indeed, it's right here in this report. But it is not anywhere to be seen in Bill 11. And I think what Albertans are looking for is government to be very clear, as it pretended to be with the Premier's public health guarantee, as it pretended to be in a number of its very bold promises, but has utterly failed to follow through on, in terms of being truly accountable and truly invested in actual work to support the entirety of our public health care system. With that said, I think there will be much more opportunity for debate on Bill 11. I look forward to more opportunities to rise.
Thank you, Honourable Member. Are there any members looking to join on RA1? I see the Honourable Member for Calgary-Buffalo has risen.
Thank you very much, Mr. Speaker, for this opportunity. And just to remind, I guess, myself and other members of the legislature, RA1 reads, Bill 11, Continuing Care Act, be not now read a second time because the Assembly is of the view that the government has not carried out sufficient consultation on the contents of the bill with families whose loved ones lost their lives from COVID-19 while in continuing care. And I certainly support this RA1, this referral, for that purpose, Mr. Speaker, because it's important that we learn from those who have lost their loved ones, those who saw early on, and we know that there's coming up to about 1,700 Albertans have lost their lives, have passed in continuing care, and the first and second waves of that pandemic in this province, not unlike its effect in other provinces, was devastating to those many individuals in continuing care. And Mr. Speaker, that should be reason alone for learning more about learning more about what residents or loved ones of residents believe should go into the Continuing Care Act of Bill 11, and to make sure that it has the agency and efficacy to ensure that the lives of people who are in those facilities is as good as possible, as protected as much as possible. In Alberta right now, Mr. Speaker, there are more than 33,000 supportive living spaces, more than 15,000 long-term care spaces, and there are more than 127,000 Albertans receiving home care each year. So we know the ripple effects of lives impacted by, in Alberta and elsewhere, by the act that's before us, that it will be bringing together several other acts and putting them in one place, Mr. Speaker. We know that the lives impacted across Alberta of those 127,000 Albertans receiving home care, 33,000 in supportive living spaces, and more than 15,000 in long-term care spaces. You know, it spreads out from there. And so those individuals, I think we're arguing, would have a great deal to say about this act at this time, and why they should be included in a review, further review of the results of the government pulling together and trying to modernize to some extent, and trying to streamline and improve what's currently in several very dated acts. The facility-based review of continuing care final report we know came forward on May 31st, 2021, so approximately 11 months ago, Mr. Speaker. And that review included, of course, had consultation as a step in the process to completing its report, but it also had 42 recommendations that would, as I said, transform and modernize Alberta's facility-based continuing care facility. And it would be useful to not only ask Albertans who have experienced firsthand the devastation of COVID-19 on their loved ones, but it would be useful to ask Albertans, now that the bill is before us, does it have the appropriate transparency, and does it have the appropriate legislation identified in it that will address the needs that Albertans know too well from their experiences with their loved ones. You know, the impact of COVID on this province and the people of this province, some medical practitioners are saying, and others are saying, that there's going to be a significant portion of Albertans who now experience long COVID as a result of their contracting COVID and having it in the first place. And what, Mr. Speaker, will be the impact on our continuing care system? What will be the impact on our supported living spaces? And, of course, receiving home care. Home care needs going forward. My suspicion is that there'll be more Albertans who go to those facilities or are treated at home for long COVID. And that's another reason, I think, Mr. Speaker, we should have the opportunity to allow Albertans to come together to look at this bill in greater depth with legislators to make sure that we're getting this right the first time, Mr. Speaker, because it's Albertans' health is too important to leave continually to updates or amendments or changes to the Act. We can deal with it. One of the challenges, of course, with the current bill before us is that much of it will be addressed in regulations down the road. And I think that's a problem, as my colleagues have talked about already, that saying we're going to get this right is not a transparent way of governing, Mr. Speaker. Saying we're going to, trust us, we'll go into the back room, essentially work with bureaucrats and others to develop regulations that'll then come to the minister and sign off, or go through cabinet committee to get sign off, is not an upfront way of dealing with probably the most significant issue that has hit this province on a health perspective ever. I can't remember. Well, I'm not old enough to know about the Spanish flu. That was in the early 1910s, and
You're not old?
yeah, okay. You don't need to chime in about that one. I've never, been in this province for 42 years. There's not been a pandemic before in this province. So to kind of point out that we just can't leave this to the back room and decisions being made is just reality, Mr. Speaker. We need the opportunity for Albertans who have suffered greatly to talk about it, to work through it in terms of this bill and what it will do for future pandemics. And I don't know any province that has taken the opportunity to listen to their citizens around the impact of the pandemic on their loved ones and the ones who are lost. I think that's an oversight that needs to be rectified and can be rectified with this RA1 referral before us, Mr. Speaker, because the trust us will get it right, and everything will be better going down the road, and we'll head off future pandemics by the new regulations that get put in place. That's too much an ask for Albertans who frankly are concerned with some of the actions of this government. We know that steps were taken by this government to ensure that moving forward on a privatized agenda could take place. And a really critical person in the healthcare of Albertans was the CEO of AHS, and that person's no longer here. Right in the middle of a massive health issue that all Albertans and Canadians have dealt with, and indeed go farther. A person who helped guide and address the needs of a significant area of our government of over $22, $23 billion expenditure is no longer there to guide that ship. So, kind of saying, the government's saying we'll create the regulations about continuing care and all those other things. While people like that, while Albertans have seen people like that kind of be shown the door, is something that undermines trust, Mr. Speaker. I think that Albertans are right to say that people need to be held accountable for these things, and it's particularly in the long-term continuing care situation. And what we saw was that residents and the families of residents aren't able to take steps to do that as a result of actions of this government in terms of some of the previous bill that was brought in. So to say the least, I think the government's failed residents of continuing care. We have brought up many reasons why we think this should be looked at in greater detail, but there's been no interest, I would argue, from the other side of looking more deeply into that. The home care situation is a very good one as well. Not only will there likely be greater home care needs as a result of long COVID going into the future, but this government talked about, more than a year ago, talked about putting more time and expenditures towards that. And certainly think that that's the low-hanging fruit, Mr. Speaker, in terms of health care for Albertans. If they can, well, prevention is obviously the lowest hanging fruit, making sure that Albertans know that they should look after their health care, go to see primary care doctors on a regular basis, take care of their dental, their other, just in kind of a holistic way, look after their own health. That's the best thing that can happen. And then follow that up with, when home care is required, that there be adequate home care to cover the needs of Albertans, so they don't have to go into, more acute care. That's something I think Albertans should have the opportunity to weigh in on as well, and why this should go to a committee to have more sufficient consultation. The number of hours residents receive in continuing care facilities and supportive living facilities is another thing the government talked about, which I'm not aware in this bill actually takes place. And we have to wait till regulations again. And my colleague from Edmonton City Centre talked a great deal about the situation with regard to staff working in continuing care, or indeed across the healthcare spectrum, and how the proportion of staff working full-time has been dismal in terms of continuing care. And it's not only here, it's across the system. I think you could probably say it's systemic. And that needs to change, Mr. Speaker. And the federal government provided some support to help that to take place. And I will get ready to take my seat and listen to other debate on this referral amendment.
Thank you, honourable members. Are there any members looking to join debate on RA1? I see the Honourable Minister of Municipal Affairs has risen.
And I'll be brief, Mr. Speaker. I just was listening to the last speech and a little bit dumbfounded. The folks across the aisle, through the whole time of COVID, argued against essentially every single decision that the government made. Like everything that was done in the healthcare system was wrong. Then we just heard one of them stand up and talk about the former chair of AHS, who's a fine person, like never did anything wrong in their life. And I don't know if that person did ever do anything wrong with their life. But the fact is, the same folks that complained about every single health care action and decision for 2 straight years now stand up, incredibly hypocritical, and talk about the person leading the effort on the healthcare side like they were perfect. Well, Mr. Speaker, no one's perfect, and the person leading Alberta healthcare at the time was a fine, good, and decent human being, and we should all thank her for her service, and we do. I just had to point out the incredible hypocrisy we just heard here after 2 years of complaining about everything that AHS did, and then standing up here and complaining that the person leading that effort isn't there anymore. It just, the hypocrisy is just way too obvious to ignore.
Are there others? On amendment RA1, the honourable member for Edmonton Highlands Norwood.
Well, I'm not certain I can follow the Minister of Municipal Affairs' eloquent, lengthy comments on that bill. But I do have to say, it is, I believe this is the second or third time that I've spoken to Bill 11, and my colleagues have raised some very thoughtful questions in this chamber. I recall actually the member from Calgary Mountain View, her introductory comments on this bill were quite thoughtful, and she'd actually done a very thorough analysis of the bill. And, it's possible that I missed the responses, but I don't think we've gotten to hear from the members opposite on this bill, and I don't think we've heard much in the way of answers to the many thoughtful questions that have been posed. And so, always the optimist. Hopefully, we will get some more government members rising in this chamber and sharing their thoughts. Because as I said in my previous remarks on Bill 11, continuing care and the healthcare system more broadly continues to be one of the top issues that I hear about. And, I know we've said this many times in this chamber, and we will continue to say it, but, we pride ourselves on talking to our constituents and, and voter contact and connecting with our constituents at their doors and on the phones. And as my colleague from Edmonton City Centre pointed out, not just in our own ridings, although we all are spending a whole lot of time in our own ridings, but around the province as well. And, I've spoken about how I've had the chance to knock on doors in Calgary quite a bit, and I'll be back there on Saturday as well, talking to the fine folks of Calgary East, I believe. And I'm certain that healthcare will be a top concern of folks there, because it's quite interesting. While our riding demographics might differ, I think of the time I spent door knocking in Strathcona Sherwood Park not that long ago, or Morinville St. Albert as well. Quite different demographics than much of my riding in Edmonton Highlands Norwood. Yet the common issues transcend our ridings, and healthcare is certainly one. Yeah. And I can absolutely say that continuing care has been something that's come up at the doors. Not as much as healthcare broadly, or education, particularly curriculum, as I look at the member from Edmonton Glenora. I know we've heard that one a lot, but continuing care has come up. And as I talked about in my previous remarks on this bill, I've not had the opportunity as much lately, given the pandemic and wanting to be safe with my constituents, that I haven't visited as many seniors' homes as I would like, and I do miss that. I really do. I've always really loved connecting with seniors, and I just can recall from not long after being elected, some of the great folks that I met in seniors' homes, in particular seniors' residents that I represent. And I shared, quite recently that there have been continuing care facilities in my own riding of Edmonton Highlands Norwood, where there have been really, really the impacts of COVID have been really, really stark, including in the Chinatown Care Centre in my riding. And I was actually just in the area not too long ago. I was at the Chinese Elders Mansion. If you've been in the area, in Chinatown, the area, I'm so proud to represent. There's a few facilities there. They're not all run by the same organization, but they're all in close proximity. And I was there not long ago and just chatting with, actually dropped off an Alberta flag, because their old Alberta flag was quite tattered. And so I was happy to do that. And just chatting with them about how things were going there. And they said, yeah, it's been tough, right? It's been hard on residents not being able to see family as much, and just the loss in the Chinatown Care Centre in particular, significant loss of residents. They have a lot of quite older folks in their 80s and 90s who we lost to COVID. And, I can share similar stories from some of the other folks that I've chatted with throughout my riding, because, the people that we lost in the area that I represent are just some of the over 1,600 continuing care residents that have passed from COVID-19. And I've got those numbers from the end of March, and so I would hazard a guess that those numbers are even higher now. And this is why I should mention, before I forget this is why, to make it clear to the Speaker, this is why we're calling on this government to take our advice and accept our amendment on Bill 11, the Continuing Care Act, which will ask for Bill 11 not to be read a second time. And our biggest concern about this bill, as has been delineated by my colleagues in the chamber tonight, is the lack of consultation on this bill, and particularly the lack of consultation on the contents of the bill with families whose loved ones lost their lives. And I would urge this government to go to some of the continuing care facilities in our riding. Perhaps in my riding in particular, perhaps the Minister for Seniors and Housing, she was in Chinatown. Just gosh, time is confusing. When was that? That was yesterday. Thanks, City Centre. Thanks for that. That was yesterday. My brain. But it was great to host her in my riding. We were at Dynasty Century Palace, and she was there from the UCP, and myself and my colleague from City Centre and Edmonton Whitemud were there from the NDP, and there were quite a few elderly Chinese members of our community there. I can imagine that many of them do live in some of the housing that I mentioned earlier, particularly the Elders Mansion, the Chinatown Care Centre, has a few examples. And as I said, and again, we're always so happy to support Chinatown and to listen to our constituents. I've said this in the House a few times. A lot of the folks who own businesses and whatnot in Chinatown, they might live in other areas, but some of them do have elderly parents and whatnot who are in some of those facilities. And I was mentioning not too long ago that I chatted with someone who'd lost her grandfather in the Chinatown Care Centre, and she'd pointed out that he was old. I need to remember how old he was. I believe she said in his 90s. He was old, but he was healthy, and he didn't need to die. But COVID really swept through the care center, and so I say all that context because I don't think she was consulted, and I don't think a whole lot of family members who lost loved ones to COVID were consulted, and we can see that in a few other pieces of this bill, and that's why we're urging this government to truly heed our advice. And I've said this, in my previous comments. I said, this government had an opportunity. I was talking with someone actually earlier who works with healthcare in this province, Friends of Medicare. In fact, I'm sure he won't mind me mentioning that I was chatting with him about a few healthcare issues. His name is Chris Galloway. He's the new executive director of Friends of Medicare, and he's doing a great job in that role. He's got a lot on his plate, I must tell you. He truly does. He came into that job with a whole lot to deal with, and we were just chatting about some of the important stakeholder meeting. Of course, we were just chatting about some of the legislation in front of this in front of us today, and I pointed out that There are so many things that this government could be doing. They could be taking very much transformative action to improve our healthcare system, to address the funding gaps in education, to improve the continuing care system. And sadly, instead of doing that with this piece of legislation, it's very much a lot of administrative work that's been done. And I just had the bill with me, but even just the title of the bill, the Continuing Care Act, someone might think that a lot's being done, but it's certainly not. And we're disappointed that when presented with the opportunity to bring about substantial change and to really transform a system that countless Albertans are telling this government needs improvement, they've chosen not to. And so that's incredibly disheartening. It's disheartening to us as the opposition who've heard from families who've lost loved ones in continuing care. It's disheartening to healthcare workers in continuing care facilities. And I really appreciated I always appreciate his comments because they're always so thoughtful, but I really appreciated the member from Edmonton City Centre's point that, many of these workers do come from marginalized communities. There's a large percentage of continuing care workers who are racialized women, and many of whom would tell you if they had the opportunity without fear of reprisal that their working conditions are just dreadful in a lot of these facilities. And so, this bill, it doesn't even fulfill the UCP's own promises from a year ago, which were quite a few, but among which were increasing home care, increasing the amount of hours of care that residents receive, and increasing the proportion of full-time staff. And it fails to make substantive and meaningful changes when it could have done so. And the other big concern, we've touched on this a lot, and as I've said many times in this chamber, trust and lack thereof is becoming a consistent theme with this government. And so what this government is doing with Bill 11, the Continuing Care Act, is they're going to leave a whole heck of a lot to regulations, and they're asking Albertans, they're asking us, the opposition, but I'm more worried about Albertans. They're asking Albertans to just trust them that the changes that they want to make are going to be happening in the spring of 23, and that they're going to make the right decisions through regulations. We've heard that on countless bills already. I mean, I've only been in MLA since 2019, but the number of times where we've been told that things will be settled, figured out in regulations is quite troubling. And so we cannot trust this government to just leave things to regulations. Now, I know I don't have a lot of time here left, but I just want to quickly touch on the fact that there was, and again, I remember my colleague from Calgary Mountain View digging into this quite deeply. So for those of you watching at home, again, of which I know there are many, especially with that Oilers game raging on, but for those of you watching at home, do look back in Hansard and read some of those comments. One of the big concerns was around the fact that this government has not acted on the recommendations in the facility-based continuing care review. And we've asked multiple times, again, we've not heard answers, or at least I've not heard answers when I've been here in the chamber, on why they're not acting on those recommendations, such as increasing the amount of home care provided, improving the working conditions, as we talked about, the often quite challenging working conditions, particularly in the midst of a pandemic, that those working in continuing care are experiencing. And increasing the amount of full-time staff. Hiring more people isn't necessarily going to fix all those working conditions, but it sure would help, especially for those continuing care workers who we are hearing from, who are just beyond exhausted, right? And working unbelievable hours and multiple shifts. And we're asking this government, will they, and this is why we'd suggest that they very much delay this piece of legislation. We're asking them to share the consultation report. What specifically is being supported by stakeholders? So we've got a lot of questions, but we're not getting a lot of answers. Thank you, Mr. Speaker. And
Other. We'll say the tie goes to the runner in this case. The honourable member for Edmonton Highlands Norwood has moved to adjourn debate. All those in favour, please say aye. Aye. Any opposed, please say no. In my opinion, the ayes have it. That motion is carried and so ordered.
Under Government Bills and Orders for second reading, Bill 16, Insurance Amendment Act 2022, adjourned debate, MLA Irwin.
Are there others? The honourable member for Calgary Mountain View.
Thank you very much, Mr. Speaker. I am pleased to rise and speak to Bill 16, which is the Insurance Amendment Act 2022. And I think it is worth specifying because we've had actually quite a lot of insurance-related amendment acts in this last little while. So, what is this bill about? So, it solves a problem, according to the government, that actually does exist, and I think they are correct in this. I am not in any way challenging this proposition. So, the government says that it's challenging for certain companies in Alberta to obtain reinsurance. And this is due in part, I think, to oil sands companies being unable to attain this type of insurance because of climate change. Now, this sounds a bit odd, but actually reinsurance, so companies will buy insurance for a loss, they'll buy potentially excess insurance for losses over a certain point, and then they will buy reinsurance. So the reinsurance is kind of the third level. Something really, really big, really, really bad, really very expensive has to happen to get to the point where you're dealing with reinsurance. And the challenge, as I understand it, is essentially that because potential damages arising from climate change could be so large, depending on sort of which way things fall out, it's difficult for these companies to obtain the insurance that they need. So it is a real problem, and I am glad to see the government moving forward to solve it. I think that this is overall a good bill insofar as it goes. I don't think there's any major concerns. So essentially what the bill does is three things. So it allows Alberta-based companies who have a captive insurance company outside of Canada to bring them home. Essentially, if a company that resides here has a subsidiary that does insurance, but it's located elsewhere for various reasons, they can bring them home with no interruption in coverage, which I believe is called redomestication. So far, riveting. It also allows Alberta to license standalone reinsurance companies. So I don't think anybody really knows if this is going to work, but it is actually what I would say is sort of a genuine good faith attempt to do this on the part of the government. I don't give them a lot of credit for good faith, so I guess I'll take the opportunity where it presents itself and list it here. So essentially what it would do is allow a standalone reinsurance company to be created in Alberta. I think the hope there being that because it is primarily oil and gas companies that are having difficulty obtaining this insurance, that because there's a lot of capital floating around that they might bring that together and create a company. I would need to do a lot more research to say whether or not I would even want to hazard a guess about whether it'll work, but I think it is a genuine attempt to solve a real problem on behalf of the government, so good for them. The third thing it does, it allows Alberta companies to access unlicensed insurance. So the reason certain insurance is not licensed in Alberta is essentially because it depending on where the insurance company is located, if the insured were to have to sue the company because they decided just not to pay out even though they were liable for whatever reason, it would be very, very difficult to obtain such a judgment. So essentially it's just sort of highlighting an unlicensed insurer is unlicensed because the body here in Alberta doesn't believe there is sort of a really good way to force the company to pay out. So it's not ideal insurance, but when you cannot obtain anything else in the market, it is something at least. And so previously, the tax rate paid on premiums for that sort of insurance was 50%, which is pretty high. This would reduce it to 10%. So the idea behind charging taxes on those premiums is to sort of disincentivize the behavior. So to incentivize companies to use a normal insurance company if they can manage to do that. I think the 10% is probably still sufficient to disincentivize taking unlicensed insurance over licensed insurance. And so it's probably a good move, again. So, again, most of what's in this bill itself, I would say, is a good move. It solves a genuine problem. I anticipate supporting it. But I would love to see the government approach the struggles of everyday Albertans with the same sense of urgency that they approach the struggles of large, profitable corporations. I just, this isn't the first bill we've had that deals with this sort of insurance. It's not that anything in the bill is bad. It's just, it's a really interesting signal of priorities. So we have this coming through after previous bills that were sort of aimed at similar problems. Meanwhile, we have the government wanting to act on, or claiming that it wants to act on skyrocketing utility rates for consumers. The government announced a rebate on natural gas. As it turns out, that rebate wasn't coming forward from at the time it was announced, it was months. It doesn't come in until this coming fall, so October. At the time it was announced, it didn't appear that the prices were going to actually reach the level that had been set. As it turns out, world events have intervened, and in fact, gas prices have come up. There was some musing on behalf of it might have been the Premier, it might have been one of the ministers, about having that come sooner, and then someone else contradicted the musing, so apparently we're not going to see it until fall. And so, it's a very slow approach. Then we have the electricity rebates. The government announced it was going to do this, and then crickets for weeks and weeks and weeks, crickets. And so after those weeks and weeks and weeks of crickets, we finally had an announcement. A bill was brought before the House. And as the bill was dropped, the minister said that Albertans wouldn't see the money in their pockets until June or July. The official opposition acted quickly. We drafted amendments to put a timeline in there to make sure that that money was getting to Albertans in a timely fashion, because it was an urgent situation for them. The government not only rejected our amendments, but the minister now likes to claim the fact that 6 days, he said it today in the House, 6 business days worth of delay is what caused, the months and months and months of delay. I think that's pretty transparently absurd, but it is a little funny side note. So I guess my point here is I would love to see this government approach the concerns of the voters in this province with the speed with which it addresses the concerns of large and profitable corporations. We also saw the government sort of race out the door right in its first term. a tax cut to large profitable corporations, and then it rushed that. So in the first year, which was pre-pandemic, Alberta lost net jobs in that time frame. Not only did the proposed solution fail to solve the problem, things in fact got considerably worse. And so having demonstrated that their initiative failed entirely, the government rushed to speed it up and did 3% drop in 1 year, which also failed to create any jobs. In the meantime, they cut a series of programs under the NDP that had sort of demonstrated histories of helping the Alberta Investor Tax Credit, some specific tax credits around the tech sector. Now, it subsequently actually brought some of those back. So while not having actually verbally admitted that it was wrong, I would consider that an admission that the strategy was incorrect. But the point is that while all of this rush happened, we have them rushing to move tax rates for regular people, but not in the same direction. So they will see an additional $1 billion from bracket creep, which is something the current premier actually used to rail against in opposition in the federal government. So I guess, well, that's some comment on what principles are worth to him. So I think the general problem here, again, is not with the bill. The bill itself doesn't do anything wrong. I've said this about a number of bills. The problem is it just sort of signals a set of priorities that I just don't think are the priorities of Albertans. I think that this government has a really big hurry to help those who have a lot of money, and they need to be in a bigger hurry to help those who don't. And so with that, I think I will take my seat. I will say we'll be generally supporting this bill.
Members, are there others? The Honourable Member for Edmonton Glenora has the call.
Thank you very much, Mr. Speaker, and to my colleagues for the opportunity to engage in debate regarding Bill 16, the Insurance Amendment Act 2022. And I want to take a second here. I'm going to directly connect this to debate, Mr. Speaker. Celebrate that we're tied up at 3-3 right now, and just say how grateful I am that Darnell Nurse was well enough to be back in the game tonight, and of course has already got at least one assist. And how it connects to insurance, Mr. Speaker. Yesterday's, thank you for that. Yesterday's media coverage says, quote, as insurance, the Oilers recalled Broberg from the AHL. But of course, tonight he doesn't need to play because Darnell Nurse is back in. This is one of the reasons why it's so important to have insurance. It's not that you're planning on needing Broberg, but there are times where you might have to lean on a junior from the AHL to step up and fill that backlog. And I'm going to take a minute just to also share a story about insurance. And we were talking about this with, because of course, financial literacy is something I've been advocating for greater improvement in curriculum for many, many years, Mr. Speaker, including the time when I was on the Edmonton Public School Board. So I try to take opportunities to, with the young people in my life, to talk about components that relate back to financial literacy. And pardon me? And I'll look at it later. And I have to say that the conversation I was having with my niece and nephew, this was probably a year ago, around insurance. We talked about how you want to buy insurance for things that you can't afford to replace, like your house is usually the biggest investment that most people make, your vehicle, and of course related to that is injury insurance and the fact that you might be in an accident with another vehicle. And then we talked about life insurance, and immediately my niece said, so what does that mean if my dad dies, I get another dad? Because of course, if your house burns down, you get another house. If your vehicle gets totaled, you get another vehicle. And then we talked about how, of course, no, she wouldn't get another dad. But we talked about the earning potential that he would have to contribute to his family over his working years, and how that was something that they would need to ensure was there for them and their family to provide for their future if something bad happened to one of her parents. And I have to say, I think, as the colleague who spoke just prior to me has mentioned, there aren't a significant number of red flags in this bill, and that for a change makes us inclined to probably support it. The government has taken many opportunities to, I think the only piece of legislation, which I will refer to it as, that's been changed more than insurance. Well, for sure, the standing orders have been changed far more times than insurance. They've been changed more in this sitting of the legislature than I imagine probably the last 5 or 10 combined. So it's interesting that we continue to see additional changes to the standing orders and proposals around that. And now here tonight we are considering additional changes to insurance. I would say that one of the big things when people talk to me about insurance that they want to see, though, is that their bills become more affordable and more predictable. And I can't help but be reminded of conversation. Actually, I think it was, I think he just spoke earlier today, but prior to that, the last time the now member for Fort McMurray, Conklin? Is that the name of the riding now? Fort McMurray Lac La Biche. Thank you very much, Mr. Speaker. The last time prior to this recent iteration of re-election that the member for Fort McMurray Lac La Biche spoke in this place, I believe his final exchange and question period was related to insurance. And the fact that insurance wasn't consistently, the policies weren't consistent for residents in Fort McMurray, but there were many different types of insurance packages, and that sometimes neighbors living side by side who both lost their homes had very different coverage, and they weren't aware of the fact that their policies were that divergent. So what I would love to see in terms of insurance in this place, and I imagine the member for Fort McMurray Lac La Biche and others would probably agree, is more focus on affordability, more focus on comprehension and having consistent packages of services available for those who might need them as it relates to automobile, home, life insurance, and other major insurance products. So those are some of the things I would love for this Assembly to focus its time on, things that actually directly impact affordability and ways to make life better for everyday Albertans. I don't think that this bill is problematic, but it definitely doesn't give me the kind of enthusiasm that I would have if we were actually addressing some of those significant root problems that people regularly talk to me about throughout the province of Alberta when it comes to what could be done to address insurance as we move forward. Thank you very much, Mr. Speaker.
Members, are there others? The Honourable Official Opposition House Leader.
Thank you very much, Mr. Speaker. I'm pleased to rise to speak to Bill 16, Insurance Amendment Act, its second reading, my first opportunity to address this piece of legislation. The bill primarily does three things: making changes to captive insurance companies, building off of the changes that the government passed last year. It makes changes to allow Alberta to license standalone reinsurance companies. And it makes it easier for Alberta companies to access unlicensed insurance. And based off of the debate that we've had so far, based off of the support from the energy sector that we've seen for this piece of legislation, and based off of the remarks and the research I've had the opportunity to do, it's my intention to support Bill 16 at second reading because of the three things that it is doing and the need for that, given Alberta is in a hard insurance market, and this change will bring Alberta more in line with other provinces and make sure that we can get viable insurance products easier for industry. That being said, Mr. Speaker, I cannot rise in this place and speak about insurance in Alberta without talking a little bit about what I'm hearing from my constituents in Melwoods, who are more and more struggling with the rising cost of living and rising cost of their own personal insurance items. Now, in seeing the Insurance Amendment Act introduced and in considering it at second reading, which is looking at kind of the high level of this piece of legislation, I'm very disappointed that this bill does not do more to address what have been some very serious and expensive to Alberta families changes that have come about since the UCP removed the rate cap. We have talked about the cost of insurance rising and the impact on families in this place a number of times. In fact, it comes up during question period quite frequently. And it's certainly not something that the government is unaware of. And so when the Insurance Amendment Act for 2022 was introduced, I genuinely hoped that we would see more support for Albertans. And unfortunately, it does not exist in this piece of legislation. And what is missing, that support for drivers, that support for homeowners on their home insurance policies, is really incredibly important. Now, we know that the government just recently released the Superintendent of Insurance 2020 annual report. It found that car insurance industry was charging Alberta drivers $385 million more in premiums in 2022 than they did in 2019, during a time period where drivers were actually spending less time on the road. And I would have liked to have seen in Bill 16, the Insurance Amendment Act, something to address this. Across Canada, other jurisdictions were actually providing rebates to drivers and to Albertans to help offset potential costs and to acknowledge that during a pandemic, people in many cases used their vehicles less. Certainly that wasn't universal to all experiences during the pandemic, but for many, many people it was true. And so here in Alberta, rather than providing rebates, we saw Alberta companies collect $1.3 billion more in premiums than they paid out in claims, boosting their profit margins and expanding their gross margins. And not surprisingly, this report was delayed, not released. We were told it was unimportant, that the information was available elsewhere, which it was not. And then the report was dropped late on a Thursday before a 4-day long weekend, which is a sure sign that the government is not that interested in Albertans noticing it. Unfortunately for the government, Albertans did notice that report. In fact, I was door knocking just the week after, that weekend actually, that the report was dropped, and people were bringing it up to me on the doors. That they had seen this was happening. And certainly when I'm out talking to constituents and talking to Albertans in other parts of this province, affordability issues are absolutely the #1 concern that is impacting their pocketbooks. We have talked about this as well, Mr. Speaker, in this House, but just recently we saw a report that said Albertans say they're $200 away from being unable to meet their monthly financial obligations, one of the highest rates in the country. And I think we need to think about that incredibly seriously. And so the official opposition has called for a 1-year freeze on car insurance premiums, something that would save Albertans $360 million on their insurance bills and take action to help fight rising cost of living. And the government it disagrees, as we do not see that type of policy in Bill 16, the Insurance Amendment Act, where it would have certainly been most welcome. In fact, instead, we see last year's rates skyrocketing, in some cases up by 30%. And even just this month alone, Mr. Speaker, we've seen 5 rate hikes, with Premium Insurance Company going up by 5%, the Dominion of Canada General Insurance Company going up by 5%, Aviva Insurance Company of Canada going up by 5%. That's just this month, on top of the previous increases that we've seen. So, while Bill 16 does not address rising car insurance costs, which I wish it did, costs are going up for Alberta families as we speak in this very chamber. And so I'm disappointed that Bill 16 doesn't do more to address the very real concerns that Albertans are talking about at the doorstep, and that the concerns of large companies, as my colleague from Calgary Mountain View, seem to rate as a higher priority than the concerns of average everyday Albertans. That the profits of insurance companies are ahead of the budgets of everyday working families. We've recently seen numbers even in the budget documents that, based on the projections for revenue growth on the Alberta government's tax on car insurance premiums, Budget 2020 projects that Albertans are going to pay $891 million more over the next 3 years. And that's accounting for inflation and population growth. That's a lot, Mr. Speaker, and that's on top of an Alberta public that already so many of them say they're $200 away from being unable to meet their monthly financial obligations. So these are serious topics, Mr. Speaker, and while I support Bill 16, the Insurance Amendment Act, for the 3 things that it does do, I am incredibly disappointed for all of the things that it does not do. Which is it does not support Alberta families. It does not address the problem that the UCP themselves introduced when they raised the cap on insurance prices that was put in to protect consumers. That they say insurance companies were leaving, except none had. They were about to leave, except none did. And instead, we have Alberta families that are paying more and more and more each and every day. On top of course, the affordability crisis that we have with electricity and utility costs going up, food and gas prices with the inflation that we've seen, tuition, oh my gosh, tuition is going up hugely, school fees, over and over and over, park fees, each and every one of these things that I've named are policies that the UCP government has changed that is making life more expensive for Alberta families. And I haven't even talked about the insidious bracket creep tax changes that they've put in, or Friends of Medicare and the important work that they are doing to advocate for Alberta families. Because, of course, our healthcare system is being underfunded in so many ways, and our healthcare workers are stressed and have been carrying so much weight throughout the pandemic. And so, on this important Bill 16 piece, I will be voting in support of the Insurance Amendment Act, but I had to use my brief time at second reading to express my disappointment in all of the things that the Insurance Amendment Act does not do. Again, to be entirely clear, Mr. Speaker, because this is what I'm hearing when I talk to families, when I knock on their doors. It's a very real concern each and every day. And while Bill 16 is doing 3 very good things, and it has the support of the energy sector and the Voluntary Reinsurance Task Force, it doesn't take action on what's most important to Alberta families. And so, as a member of the official opposition, I really just needed to make sure that I represented the voices that I've been hearing and the constituents that I represent. So thank you, Mr. Speaker, for this time to address Bill 16.
Members, are there others wishing to join in the debate? Seeing none, I am prepared to call the question. Honourable members, on the motion, second reading of Bill 16, the Insurance Amendment Act 2022. All those in favour of the motion, please say aye. Aye. Any opposed, please say no. In my opinion, the ayes have it. The motion is carried and so ordered.
Bill 16, Insurance Amendment Act 2022 is now read a second time.
The Chief Government Whip.
Mr. Speaker, I move that the Assembly be adjourned until tomorrow, Tuesday, May 3rd at 10 a.m.
Members, having heard the motion is proposed by the Chief Government Whip for adjournment. All those in favour of the motion, please say aye. Aye. Any opposed, please say no. In my opinion, the ayes have it. The motion is carried and so ordered, and the House stands adjourned until tomorrow morning at 10 a.m.